विलकॉक्स जो मेरे कोलीग हैं, इनको फाइन्स मिली थी यूलेज की फाइन्स। नवल का बिजनेस है स्कैफोल्डिंग का, तो उसको तकरीबन रोज़ जाना पड़ता था यूलेज के और LEZ के एरियाज़ के अंदर। तो इतने वो फाइन्स बिल्डअप हो गई कि इसको बिल आया, इसको पता ही नहीं था कि फाइन्स आई हुई हैं। तो तकरीबन 11,000 कुछ फाइन्स हो गई हुई थी। इसने उसके ऊपर वो पे तो कर दिया, मगर रिसर्च किया कि इसकी बैकग्राउंड क्या है, LEZ और यूलेज की साइंस का, ये कैसे ये ऑथराइज हुए थे और उसका प्रोसीजर क्या था। इसने सारा रिसर्च करके तो पता चला कि ये तो एक्चुअली साइनेज गलत है, इसके ऊपर जो डिटेल्स होने चाहिए, करेक्ट डिटेल्स, वो नहीं है। यानी कि किस वक्त ये अप्लाई करता है, कौन से दिनों को अप्लाई करता है। हालांकि यूलेज के तो हर वक्त अप्लाई करता है, मगर उसके ऊपर लिखा हुआ नहीं है कि एट एनी टाइम। दूसरा, एक दिन है साल में जब नहीं अप्लाई करता, क्रिसमस डे, इट डजंट अप्लाई ऑन क्रिसमस डे। तो क्योंकि एक दिन है जब ये नहीं अप्लाई करता, वो साइन के ऊपर नहीं लिखा हुआ। नवल ने अपील किया कोर्ट में एडजुडिकेटर की डिसीजन लेने के लिए। उसने रूलिंग किया इस नवल का एविडेंस देख करके ये बिल्कुल अनलॉफुल है, इसके ये कंप्लाई नहीं करता ओरिजिनल जो रूल बना था। फिर और उसने इंस्ट्रक्ट किया TFL को कि इसके पैसे वापस करो, क्योंकि ये साइंस अनलॉफुल हैं, आपको पैसे नहीं लेने चाहिए थे, तो इसके वापस करो। TFL ने बिल्कुल इसको इग्नोर किया। ये कैसे हो सकता है कि गवर्नमेंट को एक कोर्ट उसको हुक्म दे रही है कि ये गलत था फाइन और उसको पैसे दो वापस, तो वो नहीं, अभी तक उन्होंने इग्नोर किया, अभी तक नहीं दिया। पर अगर जब गवर्नमेंट का कोई अदारा हमसे लेता है पैसे और हम वापस नहीं करते, कोर्ट का फैसला होता है कि इसके पैसे वापस करो, वो बेलिफ्स भेज देते हैं, इतना परेशान करते हैं। तो ये डबल स्टैंडर्ड्स है, ठीक है। दूसरा ये है कि फिर नवल एक और कोर्ट में ये इसी साल मार्च में एक काउंटी कोर्ट में फिर दोबारा लेकर गया कि उन्होंने मुझे पैसे वापस नहीं किए। तो हालांकि छोटा सा अमाउंट था, उन्होंने पैसे वापस नहीं किए। तो फिर वहाँ पे भी जज ने ये फैसला किया, सारा एविडेंस देखकर, कि ये साइंस बिल्कुल अनलॉफुल है। और अब आप बताएं कि ये फैसला डबल स्टैंडर्ड्स क्यों है? पब्लिक के लिए एक और स्टैंडर्ड है, गवर्नमेंट के लिए कोई और स्टैंडर्ड है।
My name's Noel Wilcox. I'm a business scaffold owner. This case goes back to summer 2021, and where my company was hit with £11,500 of fine, so it was 7 penalty charge notices. I appealed to Transport for London. They rejected my appeal because when I looked at the signs, they just simply didn't contain the correct information. So when I appealed to the road traffic adjudicator, he allowed Transport for London 21 days to provide the evidence that the signs, one, were authorised by the Secretary of State for Transport, or they complied with the Road Traffic Signs and General Directions 2016. Transport for London failed to provide that evidence. So based on that, because they didn't provide the evidence to the adjudicator with the legal arguments that I had given the adjudicator, he subsequently ruled that he wasn't satisfied that the low emission zone was lawful. So as part of that, he directed that Transport for London, if I paid any penalty charge notices or I paid any charges to Transport for London, that they were to issue a refund without delay. So that's what the adjudicator directed. Transport for London have refused to pay me back the money that I paid. So what happened was, after the last penalty charge notice, I signed up to the auto pay scheme, and money was deducted because what we didn't want was all of these fines coming through. We'd already had 7 of these fines, so we didn't want that to come through. So on the 20th of March, I was in a small claims court. The judge upheld that decision, but he was limited in jurisdiction to say what had happened after the last penalty charge notice was issued. Subsequently, on the 3rd of September, I was recently in the Royal Courts of Justice, and my evidence was refused by the judge. Quite a few things concern me about that specific case. Transport for London had not complied with any of the court's directions. The judge refused to impose any sanctions on them. That would have been by way of actually striking out their evidence, not allowing their evidence to be submitted because they breached it. And guess what? Yet again, it was another administration error. And I did say to the judge, a massive corporation like this with a massive legal resource department, why are they having these continuous administration? I mean, these people are in charge of our infrastructure. Why can they not comply with court deadlines? And I had complied with all of the court deadlines, but the judge did not impose any sanctions. So I knew I was in trouble at that point there. The judge listened and took notes to all of their evidence. The judge didn't take any notes with any of the case law that I cited. So the judge struck out the claim based on the fact that by Transport for London's own admission, that they were going to have to pay back hundreds of millions of pounds and that it would cripple public services. So where do I go from here? I go to appeal. And if that appeal is unsuccessful, then it could go to the Court of Appeal. However, this is going to be heavy litigation. I know the law, but I don't know all the litigation and I don't know the advocacy. So this is going to probably require a lot of money. But I'm absolutely adamant that Transport for London are running scared because they are not providing the evidence that these signs are lawful. And I can provide the evidence that these signs are unlawful. I've seen their evidence and their evidence is very, very weak. But this is going to take quite a considerable amount of funding now because we've got to get the right legal minds who can deal with the advocacy and the litigation.